the legislation saying I'm going to wait until the doesn't have to set up those exchanges, because if he fails to do so, the state will not suffer any adverse financial consequences by that decision.
But what does this ruling, based on how we understand it now, affect somebody like Chris Christie and the people of New Jersey?
It means that the Congress is going to have to address how it provides health care to people when it has ordered the states to do so, and the states are free to resist that order because the order has no teeth to it, because the Congress can't enact any financial consequences.
Are you saying that New Jersey can still do what it wants?
Without having read the opinion, as Megan and I have not read it, but on the basis of snippets of information that we're getting, it appears as though it can, and it appears as though someone like Governor Christie has triumphed here, because he didn't spend the money to challenge it, as 26 other states did. He signed a piece of legislation, vetoed a piece of legislation, putting it into place, and now the feds have lost the hammer with which to compel him to put it into place.
You mentioned New Jersey. I would also remind you about Virginia, strong resistance, state of Georgia, the state of Florida, which really led the charge on this case.
Because, Bill, I think they are digesting this just like we are. And I really don't want to let go of what Megan and the judge were just touching on, because I think we're starting to get a full appreciation of where this may be going. If in this ruling, as we now believe, the states can opt out, there are many states, as you just mentioned, that are sued to get out of this law already. So many states will already make that choice. If there is a choice to, in fact, opt out, you don't see a way for the federal law across the board to hold its own, to stay together. So there is really a question about whether this is a positive, as much as we've been saying over the last 40 minutes, for the Obama administration. And I think that that is the key point. And on the politics side of it, you're also right in saying that the right will be fired up. We saw how much the health care law fired up, as I mentioned before, the midterms in 2010. This will only increase that turnout on the right. For someone like Mitt Romney, who had a hard time in the primary shoring up his right, this possibly could be the thing that shores it up more than anything else could.
Many have been doing that. Many haven't in the wake of this this Supreme Court case. But the Medicaid part of the act is huge, and it's supposed to cover 17 million poor Americans, to give them, the very poor already have Medicaid. This made it, you can bake basically 133% of the federal poverty level and get coverage. That's another 17 million Americans. Did they just lose that coverage? That's what we're trying to, did they just lose that coverage because the Supreme Court said, states, if you don't want to comply with that, you don't have to.
Well, the argument was over the 10th Amendment and what Washington could tell the states to do, or what they could not tell the states to do.
This is a very big deal in contemporary jurisprudence. How far into the state governments, we're not talking about now individual persons, how far into the state governments can the Congress reach? The Supreme Court has built a wall and said you can't reach into those state governments, make them raise their taxes, and tell them how to spend their taxes, and punish them if they fail to do so.
Okay, back to Shannon Bream. Shannon, it's been a couple minutes. I don't know how much you were able to get through, but are you able to illuminate any of the ideas that we're exchanging here in New York?
Well, let's talk about Medicaid. That was the fourth and final issue that was argued here. A number of states brought this lawsuit specifically on the Medicaid issue, arguing that all of the millions of new people who will be put onto Medicaid under the law, they couldn't afford it, they said. And they said that it was coercive, that they would be penalized in some way if they didn't take them on. In the majority opinion, what the Chief Justice says is that basically nothing in our opinion precludes Congress from offering funds under the ACA. We're talking about Medicaid. He said what Congress is not free to do is to penalize states that choose not to participate in the new program by taking away their funding. This was a very sore point during the arguments, because the states were arguing that there is a provision in the law, an existing law, that allows the Secretary of HHS, Health and Human Services, essentially, it sounds like it would be Secretary Sebelius here, allows them to say, listen, states, if you don't take all these new people onto Medicaid under the Affordable Care Act, we're going to yank all of your Medicaid funding, not just those associated with the new people coming onto the rolls, but everyone who's already on your Medicaid Medicaid rolls. The state said that was very coercive, it was unconstitutional, and they argued that specific point. It sounds like from the language from the Chief Justice, what he's saying is, yes, it's okay to require that they take the new people on, but it also goes on to say what we determine is the Secretary, meaning HHS Secretary Sebelius, cannot apply the statute in a way to withdraw existing Medicaid funds for failure to comply with the rest of the health care law. So essentially, he's taking that threat off the table, saying, I don't find that's constitutional.
Shannon,
it is constitutional to put the people on the rolls, but you can't threaten to take away the rest of their money.
Does that give